early June of this year. We are still awaiting judgment in that matter, and as it currently stands, we have no indication as to when judgment will be handed down. In terms of the legal framework, the process for removal is governed by two legal instruments: the Constitution firstly, and then secondly, the so-called removal rules. In terms of the Constitution, Chapter 9 heads may be removed on grounds of misconduct, incapacity, or incompetence. In our case, the motion deals with misconduct and incompetence only, doesn't deal with incapacity. Removal of the Public Protector and the Auditor General requires a finding by a committee of the NA and a supporting vote of at least 2/3 of the members of the NA. So it's important to note here that the threshold for removal of the Public Protector and also the Auditor General is higher than that of other Chapter 9 heads, which just require a majority vote. And it's clear from the certification judgments that the incumbents have a special protection because of the nature of their roles, which often involves the investigation of high-level officials and controversial matters, which of course may have adverse political consequences. As such, the removal threshold is therefore higher. The President may suspend the Public Protector, and that's entirely at his discretion at any time after proceedings of this committee has commenced, but must remove the Public Protector if the NA so resolves. Chair, I just want to mention that the basis for removal, so incapacity, misconduct, and incompetence can obviously only be properly understood against the backdrop of the Constitution and the Public Protector Act. And that's because sections 182 and 193 of the Constitution sets out this unique role that the Public Protector plays in our constitutional dispensation and the requirements to hold such office. Also relevant would be section 195 of the Constitution, which sets out the principles of public administration. So when the committee starts unpacking the evidence, it will be necessary at that stage to first have a briefing on the role of the PP, as it will directly inform whether her conduct meets the threshold for incompetence and misconduct. So in other words, members would need to acquaint themselves with the standard of conduct that is required from a person holding this office. In respect of the removal rules, those rules were adopted by the Assembly on 3rd December 2019. They define the terms incapacity, incompetence, and misconduct, and they provide the broad procedure to be followed. From the Constitution and the rules, whilst they may not be prescriptive, they don't tell the committee how to perform its task. And this, Chair, is with good reason. The rules are not unique to the Office of the Public Protector, nor are they drafted to particularly deal with this motion. The same removal rules are going to apply to any other Chapter 9 head in respect of whom a motion for removal is brought. And of course, the basis for removal will differ greatly from one Chapter 9 head to another, and even from different heads who may occupy the same position. Thus, it's left to the committee to determine, with due regard to the nature of the charges and the specifics of the matter, how it will determine its working arrangements going forward. However, whilst the rules and the Constitution are not prescriptive in terms of how the process unfolds from this point, they do provide the outline of the steps to be followed for removal, and more importantly, the fundamental legal principles that must underpin the work of this committee. It's these principles that will need to inform every decision of the committee. I've termed them golden rules, and this is my own term that I've coined. And these golden rules are, in effect, the blueprint of the process. They are in place to ensure that the process is fair, that it's balanced, and that it's beyond reproach. The first rule is that this process is a constitutional process. And Chair, I make pains here to emphasize that this committee is not conducting a criminal inquiry, nor should it be seen to be such. This is not a judicial process and it's not a litigious process. As such, the rules that would apply to criminal processes, such as evidentiary burdens, admissibility of evidence, and so on, don't find effect in our process now. They are of no application here. The process is instead ultimately an oversight process. Indeed, it does have a political element in that it will culminate in a decision by the Assembly, which of course consists of members of political parties. Thus, notwithstanding that we may use terms such as witnesses, evidence, and even charges, I must remind members that we're not here to ascertain guilt or innocence. The aim is simply to determine whether there are grounds for removal on the basis of fact and law. The failure to establish those grounds means that there can be no basis in law for removal. Thus, this will emphasize later when I deal with rationality. But in short, the process that we are going to follow must be an inquisitorial process rather than an accusatorial process. This brings me, Chair, to the second rule of fairness. The rules require that the matter be conducted in a reasonable and procedurally fair manner and within a reasonable time. Also, very importantly, that the public protector must be afforded the opportunity to be heard in her defense. And as indicated... Chair, may I continue?
Go ahead, Fatima.
As I've indicated, the rules don't prescribe timeframes, the order of proceedings, which step must be taken first, and so on. These are the working methods of the committee, and they must be determined within this parameter of fairness and reasonableness. What would be fair and reasonable in one context may not be so in a different context. The third rule is that of rationality. The decision-making process that the committee is going to follow must be rational because the committee is exercising a public power. The NA needs to make its own assessment on whether the PP has misconducted herself or is incompetent as alleged, with due regard to the evidence and the information before it. So in other words, there is no rubber stamping or absolute reliance on the panel report. As I've indicated, the purpose of that was to allow for sifting to ensure that the Assembly does not proceed with a matter that is devoid of merit from the outset. So the panel has found that there was prima facie evidence of misconduct and incompetence, but it now falls to this committee to carefully consider and engage with the information before it to determine if in fact this is the case or not. In other words, members must approach this process with an open mind and a willingness to reach conclusions, regardless of any personal persuasions. We can move to the next slide, please, Ms. Ngoma. Chair, we now turn broadly to the purpose, scope, and objective of this inquiry. The objective of this committee process is to establish the veracity of the charges. By determining whether the PP has misconducted herself and or is competent as alleged. The scope is very narrow. It is limited to the motion itself and does not include conduct that does not relate to those charges. And it's this scope, Chair, that distinguishes this in a sense from other oversight processes. Because of the very serious implications of this process, it follows that it can't be open-ended. Often in our ordinary oversight processes, we take a more organic approach. So a committee will deal with issues broadly, and then it may zone in on particular aspects or inquire on new things that come to light as it proceeds with its oversight. In this process, Chapter 9 heads must be able to respond to clearly articulated allegations, and they shouldn't, as it were, be caught unaware or in a position where they're not able to respond and defend their conduct. Hence, the limitations on the scope. The purpose of this entire process ultimately is for this committee to report to the Assembly And the rules state that that report must contain both findings and recommendations with reasons. And that inclusion of reasons speaks to that golden rule of rationality. And the committee will achieve this by assessing the charges in the motion against the evidence contained in the motion. In addition to that, the response by the public protector and any other relevant information that may come before the committee. In terms of the structure of the inquiry, I've now explained at some length that the rules and constitution are not prescriptive as to the working arrangements and methods that the committee must adopt to achieve the purpose and meet the objectives. Rather, they provide a framework which is general and applicable to all Chapter 9 heads. So these matters must be determined by the committee, subject to these golden rules of fairness and rationality, and with due regard to the nature of the proceedings. The committee should adopt a terms of reference, therefore, to agree on how this inquiry is to be conducted from this point forward. And issues such as public participation, the format of the inquiry, how the committee will deal with evidence, how it will afford the public protector a reasonable opportunity for audi, must now all be determined subject to the rules. And the committee is, of course, at liberty to address any other matter that it feels requires special attention in these terms of reference. Chair, I'm now going to go through some of those matters that we are of the view should be included in the terms of reference. The first is public participation. Section 59 of the Constitution dictates that the Assembly must facilitate public involvement in its committee processes, and that wouldn't be limited to merely the lawmaking processes, but it speaks to committee processes generally. The rules of Parliament are not prescriptive when it comes to how public participation must unfold, but the courts have made it clear that a reasonable opportunity must be given. And of course, in determining reasonableness, we have to take into account the nature of this process. And a removal process differs very much from a legislative process. And the committee should certainly not be seized with opinion and sentiment on what the competency of the public protector is. And by way of example, Chair, we know that there might be legislation heading Parliament's way dealing with the legalization of polyandry, which is the right of women to take more than one husband. It's not something that I am going to, an opportunity that I will avail if Parliament passes such a law. But one can already see that a bill of that nature is going to draw extensive public interest, and not just by persons who are able to input on the constitutionality or the legal aspects of such a bill, but people who merely wish to air their views in support or against such a development in the law. Now, in this case, the public participation process will be very wide, and the relevant committee can be expected to hear policy positions from a broad range of interested persons. In this matter, that sort of participation, where people are expressing themselves on their personal views on a matter, is not relevant. Whether someone likes or dislikes a Chapter 9 head, whether they believe that that person has done a good job or hasn't done a good job, is in fact irrelevant for this committee. That sort of opinion and sentiment is not going to help the committee to achieve its purpose of determining whether there is misconduct or incompetence. So it would be necessary that any public participation process is limited and to persons and organizations who can meaningfully contribute to this fact-finding process, either because of their involvement in a matter where the PP's conduct is in question, or their ability to share information that can assist the committee in reaching its finding. It falls to the committee to determine the manner in which it will facilitate public participation. This may include written participation, oral submissions by invitation, or a combination of those two. Our advice, Chair, and this again is our advice, but the committee is at liberty to decide what it feels best, is that the call for submissions can take the form of an invitation on Parliament's various social media platforms, and be limited in terms of scope, as I've suggested earlier. The matter has gained increasing traction in the media and is already receiving wide coverage, and a period of about 3 weeks would be sufficient in our view. The second aspect of public participation speaks to the openness of meetings. The default position in Parliament is that all meetings are conducted in open unless there's compelling reasons for closure of a meeting, and those reasons outweigh the public interest in the matter. So, of course, the de facto position must be that all of these meetings are open, and we also have the view that all of the meetings should be streamed on the YouTube channel to ensure that the public is able to follow this very important process. And then in terms of documents that the committee will be seized with whilst conducting the process, we are of the view that these should be made available to the public unless there are very strong reasons in law as to why those documents are legally privileged. Okay, we can move to the next slide, please, Ms. Nkoma. Chair, this brings me to the very important aspect of the format that the committee must adopt, or that it will adopt, to deal with the matter going forward. But before I begin with this, I think it's just important that I give the committee a brief snapshot of the documents already before the committee. This is just to show the magnitude of the matter that is being dealt with, and that may assist the committee in informing which format it chooses to follow. At present, the record is in excess of 10,000 pages. The motion consists of 4 main charges with a number of sub-charges related to each main charge. And then we also have the panel report now, which runs to approximately 119 pages. In addition to this, the committee will still receive representations from the public protector, and presumably will also receive other information during the course of the proceedings. So we can see that there is quite a bit of material that would need to be considered. So an important aspect now is, what is the format that the committee is going to adopt? In other words, how does the committee intend to gather evidence and then proceed to consider that evidence? And this could conceivably take various forms, provided that whichever form the committee chooses, it does so within the confines of those golden rules. So I've listed 3 very broad options, but there could, of course, be many variations that the committee may want to consider. And we've merely done this just to offer some scenarios and the risks attached. The first, which is the slide that we're currently on, is the use of an external evidence leader. Members will be aware that there have been inquiries in the past in which an evidence leader has been used, a recent example being the ESCOM inquiry. In such an option, the evidence leader bears the overall responsibility of presenting the evidence to the committee, and then also putting questions to witnesses and the public protector. The evidence leader, however, is not a prosecutor, and his or her presence will not in any way limit the right of members to ask questions. This, however, is a high-risk approach. The inquiry, firstly, is not quasi-judicial, and the use of an evidence leader creates the risk that the process takes on characteristics of an adversarial process. And there is the concern that an evidence leader may be seen as a prosecutor of sorts. And as I mentioned earlier, this is not a criminal process, and we must be careful to steer away from a process that creates such an impression. It may be impractical in as far as the committee needs to place a reliance on the availability of an evidence leader. Then, importantly, the process may be compromised if the committee is seen to be delegating its constitutional responsibilities. Members must not be seen to be relinquishing their powers to third parties, because the Constitution empowers members of the Assembly to maintain oversight rather than third parties. And ideally, members should be leading and directing oversight processes as per the constitutional mandate. This is not to say that the option is not feasible. It is possible for the option to be very carefully managed via tight terms of reference that clearly articulates what the role of this evidence leader is. Option 2 would be a member-led process with internal support. This would be similar to the way parliamentary committees conduct their ordinary oversight processes, where the chairperson guides proceedings and members are allowed to participate to the extent they wish or as agreed to by the committee in advance with their time constraints. The committee would be supported by an internal team of legal advisors, content advisors, researchers, and support staff. These persons have already been identified, Chair. The risk here is that the volume of evidence and the size of the committee may lead to the process becoming a little bit unfocused and difficult to manage. This is, as I understand it, the first time that we have a committee of this size. It will possibly require additional time for the study of all documents. And this is not to say, though, that this sort of format can't be managed. We can certainly enlist support staff to prepare guiding questions for members and to assist members in unpacking evidence. And it's also possible for us to split focus areas amongst members, as is done in SCOPA. In SCOPA, generally what happens is that particular members will be requested to prepare on certain areas, and they then lead the process, and other members then follow freely thereafter. The third option, Chair, is to have a member-led process, but one where we not only have internal support, but also specialized external support. And this would be a hybrid approach where the process has this external forensic support to assist the committee to unpack the evidence. And in this scenario, the role played by that external support person will be more limited than compared to a pure evidence leader, as indicated in the first option. The exact role of this person would need to be determined by the committee, but by way of example, such a resource may provide a summary to the committee on each charge, a summary of the related evidence, assist the committee in identifying issues that require further probing, and then also assisting the committee with the formulation of questions. And Chair, at this moment, I must just mention that in terms of formulating questions in advance, if this approach is taken, or even the approach where staff assist with the formulation of questions, there's no reason why these questions cannot be shared with the public protector in advance in order to allow her an opportunity to properly prepare. In this scenario, members retain the lead. They are actively involved in the process, and members can determine amongst themselves again if they also want to have some elements of sharing of responsibilities and splitting of evidence amongst them. So where some members also take the lead on certain issues. So the exact mechanics of this would have to be resolved by the committee. The risk here, Chair, like with the use of an evidence leader, is that there are cost implications. But nonetheless, budgetary issues aside, there's nothing that stops the committee from procuring via the Secretary to Parliament the sort of assistance. And that procurement happens in terms of the Financial Management of Parliament and Provincial Legislatures Act, and there is no political involvement in that procurement process. That will be done by the Secretary to Parliament. We can move to the next slide. In terms of additional evidence, the committee may want to consider any further evidence that supports or undermines the charges, and the committee is certainly not limited to the evidence attached to the motion. All evidence can only be considered to the extent that it deals specifically with the conduct that was raised in the charges, and that speaks to the earlier slide where I explained that the scope of the inquiry is limited. Persons who may be able to provide information can either be identified by the committee acting on its own after the committee's gone through the evidence, or subsequent to the public participation process. It is our view that the public protector should also be allowed to participate in identifying persons that she feels should come before the committee to give evidence. As members will be aware, this committee has all the powers that any other committee of Parliament has, and therefore it has the power to subpoena in terms of the powers, privileges and immunities of Parliament and Provincial Legislatures Act any person that it wishes to subpoena to appear before it. Generally, what we prefer to do is to invite persons, and only where they refuse to attend do we follow the formal processes associated with subpoena, just because that process is a little bit more complex and time consuming. However, all evidence must be provided under oath and subject to the parameters of the inquiry. And evidence can take the form of oral or written evidence or combination. So if the written evidence is sufficient and the committee has no further questions, then it need not call for that evidence to be orally presented. The committee should also have the power to recall or request supplementary statements if necessary. And this is particularly important because once the public protector appears, she may raise certain aspects that the committee then needs to clarify with witnesses that have appeared before it. The committee may consider any evidence that's relevant to its mandate, and irrespective of whether such evidence is admissible or inadmissible in a court of law. As I've indicated, it's not a criminal process. However, we do advise that all evidence collected by the committee is shared with the public protector, regardless of whether the committee is actually going to rely on that evidence. And this again is to ensure fairness in the process and allow her the opportunity to properly respond to evidence against her. Chair, this brings me to the Audi Alterum Partem rule, Latin for listen to the other side. This is a fundamental aspect of the right to fairness. The outcome of this process may have very serious consequences because it may result in the removal from office of a Chapter 9 head. Therefore, it's imperative that the public protector is provided sufficient opportunity to be heard. The opportunity for Audi is ideally given by first allowing the public protector to respond to the allegations in writing. Rule 129 AD subsection 3 says that the PP must be afforded the right to be heard in her own defense and to be assisted by a legal practitioner or other expert. This legal practitioner or expert may not, however, participate in the committee. In our view, a period of at least 30 days should be given in light of the volume of the documents. In determining the time period, consideration should be given to the fact that the PP is appraised of the record already, as this form part of the panel process. Nonetheless, there may be further evidence that she needs to be supplied with if the committee receives any other evidence. And of course, if the committee decides that that period should be slightly longer, nothing stops the committee from so determining. In terms of the fact that the rules don't allow the legal practitioner or expert to participate in the committee, we are of the view that this does not mean that the legal advisor should not be permitted to be present during proceedings, and also that the PP should be given the right at any time to request via the chairperson to allow her an opportunity to consult with her legal representative. We advise that there be a second Audi given, and that prior to the report of the committee being adopted, that the public protector be provided with an opportunity to make written representations on the final draft findings and recommendations of the committee. These representations will, of course, they need to be considered by the committee prior to the adoption of the report. And the purpose of that, Chair, would not be to reopen the process, but just to allow the PP an opportunity to look at the reasoning and then note any areas where she feels that the committee has in fact erred or misunderstood her evidence or whatever the case may be. And that needn't be a very a long opportunity, but that can be decided at a later stage once we know how long and in-depth that final report is. In terms of way forward, I hope the committee forgives me. I know there's a degree of information overload in what I've said. However, in the interest of ensuring that the process is fair, we strongly advise that the mechanics of the process is determined upfront in the form of a clear terms of reference. And this is important because it ensures that the public protector on the one hand, and then also the public that has an interest in the outcome of the matter is aware of how the process is going to unfold. And this TOR, of course, will assist in limiting the speed bumps that the committee is going to encounter on this journey and allow for a smoother process. So the details fall to be determined by the committee. Things like the objectives and scope of the inquiry, how public participation is going to unfold, the format that the committee is going to follow, how it intends processing evidence and giving the audio opportunity to the public protector, and then also certain housekeeping issues which I haven't really delved into because they're not legal in nature, but the resources that the committee must have access to, the format that meetings are going to take, whether they're going to be physical, virtual, hybrid, the timelines, etc., should ideally all be included in this terms of reference. And the ultimate purpose is that this guides the work of the committee and ensures a procedurally fair process that is in accordance with the rules and the Constitution. Chair, with that, I thank you. We will be led by the committee in the drafting of the terms of reference, and we will input as required further. Thank you, Chair.
Thank you, Fatima, for that detailed presentation to members about the possible work plan of our program. Maybe before I proceed, if I may ask if there's any member of your team who wants to add anything on what you said. That will be an opportunity to do so. If none, I proceed.
Chairperson, from the side of the legal office, there is nobody else on the platform, unfortunately, because they are engaged in other meetings. But I will ask whether the content advisor, the researcher, Advocate Tao, or any of the other team members may wish to input on any other aspect or anything that they feel requires clarity from what I've said.
Thank you.
Thank you, Chair.
Any of you? Advocate Tao?
Good morning, Chairperson, honourable members. Good morning to all. It's Raya Dikari. I am on the platform, but I'm very happy that Ms. Ibrahim has covered everything. Thank you.
Thank you. Appreciate it. Advocate Tao, I saw your...
Thank you, Chairperson, honourable members and colleagues. I am covered by Ms. Fatima. Thank you.
Okay. I guess that's the trend. Thank you very much. Fatima and your team. Honourable members, there is the presentation detailed and explained to yourselves. It's a very critical presentation because out of it, we must derive these terms of reference and a work plan. We couldn't just come with that here without your input onto all of these issues, because many of them will determine and inform the kind of roadmap and process that we must have. I'm going to invite you to engage with the presentation. And I'll see your show of hands for your interest. I see the end of Honorable Melder, followed by Honorable Lottridge.
Yes, thank you, Honourable Chairperson. Good morning, colleagues. Thank you for the presentation. Obviously, it's a very extensive presentation that deals with each and every possibility that may arise somewhere along the line. My view, however, is that I don't think we should take it that far, in the sense that what we are basically dealing with would be things that has already happened. We are looking back at things that has already happened in the past. And if we talk about evidence and leading of evidence and all those processes, yes, it may be relevant. But surely it's not our task to reinvestigate all the issues that were dealt with in the past, and in terms of which the public protector and the office came to certain conclusions and certain reports were drawn up and presented, etc. That's not going to be our task. So I understand about the 10,000 pages of documentation, etc. But my view would be that we need to deal with what has already happened, and that is not that extensive in that sense. So I would rather see that we narrow the scope rather than going into a process that could keep us busy here for the next 3 years. Thank you, Chairperson.
So in other words, Honourable Member, you say let's stay on the narrow scope. That's your point.
Yes, Chairperson.
Thank you, Honourable Melder. Honourable Lothrit.
Thank you very much, Chairperson. Yes, thank you for the presentation. It is extremely helpful in this process. I indeed believe that, yes, we should narrow the scope and we should not extend whatever is contained in the motions. I do think what is important for us in terms of our going forward is to decide on the actual format that we are going to use or propose, because that will determine in a large way how we're going to deal with the information. So having listened to Ms. Ibrahim, it does seem that before we can look at the actual time frames that we are dealing with, that perhaps it would be good if we discuss which would be preferable in terms of this committee, whether we would go for the evidence-led, an external person, whether we would be member-led the whole process, or the third option, which we can call the hybrid option. So looking at that, I would like to propose that, given the scope of the work, even if we look at the narrow approach, is that we should have the hybrid approach, because it does entail a lot of work. And I think members also have work. This is not the only thing we're going to do. So I would propose that we go for the third option. And from that, if we decide that, then decide on the timelines.
Thank you. Annalie, Lothrit, are you done?
Yes, thank you, Chair.
Okay, you're just not indicating when you're landing. You just stop. Thank you. I now recognize Honourable Sukas.
Good morning, Chair. Thank you, Chair. I just apologize. We are on oversight and we're driving at the moment and the connection is not very strong. I just want to make a comment and then ask a question. I appreciate the importance of keeping the inquiry narrow, especially in respect of treating the public protector fairly. However, I just want to ask, the committee has to make recommendations. Could the legal team please advise on what the scope of these recommendations should be? Can the recommendations, for example, address how to strengthen the role of the public protector and related oversight and governance institutions to ensure that all these functions work in an integrated fashion to improve accountability? That's my questions to the legal team.
Thank you, Honourable Marisukas. We got you the gist of your issues, and thank you for your commitment even on the road. I now recognize Honourable Mondli Gungubele.
Thank you, Honourable Chair. Are you able to listen, to hear me?
Yes, I can hear and I can see you.
Oh, thank you very much. Like Honourable Sugas, I'm also around eThekwini. I think whatever narrow, Honorable Chair, means, if it means we must not recreate things, that is okay. If it means before us, there's a prima facie evidence on the basis of which this inquiry is taking off, we stick to that. If narrow means that, I think that is okay. Thirdly, that we are not here to rubber stamp necessarily what the panel has done. The panel has given us a basis to do an inquiry which is going to lead us to take a decision which is parliamentary original in nature, in line with the law. So it means we give opportunity to the parliament to do what it's supposed to do, of course, activated by the prima facie report and allowing the PP to actually engage with whatever questions that the parliamentary committee is going to do. So if narrow means that, then I think we are together. Having said that, I think I want to agree with the view that speaks hybrid, in the sense that we to sort of stick to the golden rules as articulated. We are not necessarily specialized in law generally. We are members of parliament who, in my view, are the face of the employer of some kind. We need to engage in a manner that ensures that we don't cross the line on technical imperatives. At the same time, in terms of substance, as parliamentary members, we are satisfied with whatever decision that we're going to reach. Therefore, in that instance, a hybrid that ensures that you've got a specialized person who will actually set the tone in actually marking the areas of engagement, and then allowing parliamentary members to ask whatever questions, as long as they are relevant, that they deem fit for the purpose of the PP to respond. In that context, I would support the hybrid. Thank you.
Thank you, Honorable Bungubele. Honorable Siabi.
Thank you, Chair, for the opportunity, and greetings to all members who are in attendance. Of course, Honorable Bungubele said a lot of what I wanted to say. I support the view of a narrow scope as contextualized by
Honorable Siabe. As you proceed, I'm requested to ask all of you to switch on cameras when you speak so we can see you. I missed that with Honorable Sukas and Honorable Melder. If you can, thank you.
Yeah, but I'm in Limpopo. I may experience connectivity problems. Thanks very much. I was saying I'm largely covered by what Honorable Gungubele said with regard to the scope of what we are going to do. And I also support that we adopt a hybrid model of leading evidence, because it's a parliamentary process. Members of the committee would want to be seen being active, highly active in the process. And if you allow me to even go further, I would also propose further that even with the issue of sittings, of committee meetings, we adopt that hybrid approach. Thank you, Chair.
Thank you very much, Honorable Siabi. My next hand, I now invite Honorable Ompile Mautwe.
Thank you very much, Chair. Mine is just a quick one. If you look at presentation slide number 6, it talks about public participation. But what is of interest is point number 4, where it says public involvement should be limited to persons, organizations, and so forth. So my question is, who's going to be seized with the responsibility of checking who is allowed and who's not allowed, because it says must be limited. So is it the committee? Is it the technical team? Who is going to be seized with that responsibility? Because we don't want people to accuse us of not allowing them to come and give evidence. Thank you, Chair.
Thank you very much, Honorable Mautwe. Honorable Sukas, your hand is still up. Is that an old hand or is there something you missed?
Chair, I just wanted to support what was said by Honorable Gungubele and by Honorable Lutrit around the option for us to use, which is the third option. And this is in order to ensure that, you know, the process runs efficiently around this narrow scope. Thank you.
Thank you very much for adding that point and your input. I don't have any other hands. Are there any other members before I ask the team to respond on the issues raised? Any other hand? If none, can I call you, Fatima, Ibrahim, and your team to respond to some of the questions that are seeking clarity on the matters?
Yes, Chair, I've noted all the comments and the preference for the hybrid approach. There are two questions, and Chair, you can correct me if I'm wrong, but the two questions I've noted is firstly from Honourable Sukkar, and that had to do with whether the committee could make other recommendations. The main purpose of this committee is to determine whether the public protector has misconducted herself or is incompetent, and to make a recommendation based on that finding, whether she should be removed from office or not. But there is nothing that would stop the committee from making any other sort of recommendation that it thinks necessary to strengthen the office of the public protector, any elements of the Public Protector Act, for example, that the committee feels needs to be amended. These are those are things that are naturally part of any oversight process. When we conduct an oversight process, it's always with a view to strengthening and supporting democracy. In much the same way that the Public Protector has that role, Parliament also has that role. So what can Parliament do to ensure that things are better run if it finds in this process that things didn't happen the way it should have? So certainly nothing stops the committee from including those elements in its report, but the fundamental purpose and objective would be to make the finding and then to make a recommendation related to that finding. So these would be additional findings, as it were. On the second question from Honourable Matwe on public participation, Chair, the limits to public participation, as I've said, is just to avoid the situation where the committee is seized with public opinion and sentiment. So where Joe Soap, who has no real information or evidence, wants to put his or her views forward, the committee can't be seized with that sort of work, because then we'll be here forever. Because how do you then filter who we allow an opportunity to come and present and who we don't? Rather than the focus on public participation is, are there people that have evidence that they can bring to the committee as it relates to the charges? So in other words, if there is a charge that says the public protector did X, and the public protector says, I did not do that, but yet you have maybe persons that can support her and say, no, she certainly didn't do that, and I have evidence in the form of emails, or I was in such a meeting, therefore I can assist the committee in making this finding, then those are the people that we want to hear from. As with any other committee, what happens with the public participation process is that there's an internal team, and in this case, it would mainly be the content advisor that would look through all of these submissions. So we read all of them, irrespective of whether we are going to advise the committee to proceed to the stage of a hearing or consideration of it. We summarize all of it, and the committee will be provided with all of that information. So it certainly won't be a case of the team in the background simply deciding for ourselves which ones have merit and which ones don't. We will provide the committee with a summary, and the committee will also be provided with copies of all of those submissions if it so wishes, Chair. Thank you.
Okay, thank you. Any other additions from your team? Because I'd like to summarize some of the key issues and see if members are okay with my summary. Any other additions from your team? None. Honorable members, if I follow properly, just based on this presentation, we agree that we must stay on the narrow scope of the inquiry, limited to the motion. That's point number one. Point number two, that it will be important to agree that you agree and accept option 3, which is the hybrid of those other options, where we've got a member-led, but combined with both internal and external expertise. This is what I gather you saying. And in relation to the issues of public participation, that the issues must be relevant to the fact-finding mission, as raised in the presentation by Fatima Ibrahim. Am I also taking it that you have no difficulty? I think there's a next proposal of adopting a hybrid approach for this committee in terms of its sitting. Also, that you agree to this audit process that will allow fairness, rationality, and ensuring that the public protector is here throughout the process. I think those are the key issues that, in order for this team of Fatima and Ibrahim and others to come back with a final terms of reference or work plan, that these issues that you are agreeing on today would be relevant to have that process finalized. I also take it that the matters under additional evidence, those key points, I've not had a member raising any difficulty around those. So I just wanted to check if my recollection and my way of summary connects with your own understanding in that regard. And I'm going to Mr. iPad, you have your hand up.
Thank you, Chair. That's Julius Malema. I don't know if this belongs to these earlier things that we're trying to determine. In line with the principle of fairness, is it correct for us to proceed with this process while the public protector has made an application to court, trying to establish the constitutionality of this committee and the rules as it were? So I thought I must raise it from the beginning, because if we are awaiting judgment, the matter has been heard, we are awaiting a judgment. Are we not going to be accused in the future of trying to influence the outcome of the court? Thanks, Chair.
Thank you very much, Honorable Malema. I hope, Fatima, you're noting that. Honorable Jane Mananiso.
Thank you, Chairperson. I wanted just to indicate that your summary is in order based on the input of members. Thank you.
Thank you, Honorable Mananiso. Honorable Judy Hermans.
Thank you, Chair. Thank you, Chair. I want to second the endorsement of your summary as proposed by Honorable Mananiso. Thank you.
Thank you very much. Honorable Siwela.
Thank you, Chairperson. I'm supporting the two speakers. Your summary is in order and I'm comfortable. Thank you.
Thank you very much. Fatima Ibrahim, on the question, direct question that asked, maybe before that, Honorable Sheikh Imam.
Yeah, thank you very much, Chair. Thank you for giving me the opportunity to ask. I want to reiterate the question that Honorable Malema has put. My concern is if there is a matter before court and you start this process, what happens if the public protector is successful in the matter that she has before the court? And we have gone through this entire process. Now, normally I would expect that when there is a matter before court, questioning the process that we are following and whether we are entitled to or not, that until that matter is heard and finalized, my understanding is this, that the matter should not proceed. But I think maybe the legal expert Fatima could give us some guidance on that. And that's my concern that I wanted to raise. Thank you.
Thank you, Honorable Sheikh Imam. Any other comments, clarities, or interventions before I ask Fatima Ibrahim to respond? None. Fatima? Okay, hold back, Fatima. Honorable Bennett Joko from the PAC, also welcome to this family and space. The opportunity is for you. Honorable Joko.
Thank you, Chair. I just wanted some little clarity. It's based on the public participation. Fatima said that the public participation has to be limited on evidence as it relates to the charge of the public protector. In your summary on the same issue, you highlight that the public participation, it has to be narrow, looking for the evidence in this fact-finding mission. Are we looking? Is the public participation looking for the evidence as it relates to the charge, to the PP? And if it is so, what is this charge? Or should we take it from you that the public participation has to be limited to the evidence in a fact-finding mission? To me, those are the two different things altogether. I'm not too sure whether I'm correct.
Thank you, Honorable Joko. Honorable Gungubele, that's the last hand.
Thank you. Thank you, Honorable Chair. Maybe at the risk of being Fatima, I'll be very careful because that is her job. But I thought if you have gone through the documentation, there has been an attempt to interdict this process. As we stand, there's a court decision that this process, there's no legal basis for interdicting it. I'm not sure if we would want to establish another process outside that, because legally, there's a positive pronouncement that there's no legal basis to stop the process. So I wouldn't understand the basis. Maybe Fatima will answer the question because I'm not a legal specialist, because I think what Honorable Malema is asking is an important question, but where I'm sitting, there's judgment in as far as that element is concerned. But I thought it's important because in case Fatima was not here. Thank you.
Thank you, Honorable Gungubele. Fatima Ibrahim.
Thank you, Chair. As Honorable Gungubela correctly points out, the legal position is that the rules are constitutional until and unless determined otherwise by a competent court. The attempt to interdict the process was unsuccessful, and that is where we currently stand. That's on the one end. On the other end is the fact that the rules are drafted in a prescriptive manner. The rules make it mandatory for the speaker in the first instance and in the committee from this stage onwards to follow the process. It says the committee must, not the committee may. So there is no option but for the committee to continue. Of course, there is the risk that when judgment is handed down, if the court finds that the rules fall to be set aside in their entirety, it would mean that the committee then can't continue the process. And on the other hand, it may be that the court finds that there's one or two particular rules that need to be amended, in which case it may still be possible for the committee to, or for Parliament rather, to amend those rules to bring it in line with the Constitution, and then for us to continue the process. But we can't preempt, of course, what the court is going to say. We need to wait on that decision. But as it stands, the legal position, Chair, is quite clear. Thank you.
All right. Thank you very much. Much appreciated on that, colleagues. And with that, I think it concludes that item. I take it from here, Advocate Dow and your team, this first presentation and discussion and recommendations by members would assist you to address this issue of the work plan as well as the timelines on that, because before members could engage with this, you were not going to be in a position to do that. Does it do that, Fatima? Does it assist?
Yes, Chair, I certainly have enough information for myself and the team to go back and start with the drafting of the terms of reference. The nature of these things is that once you have it in writing, it's always much easier then for you to criticize, make amendments, ask questions. So our proposal for the way forward is to let us go back as a team, work on the terms of reference, and then when we present it to the committee, during that meeting, we can make changes on the screen in front of everyone and hopefully adopt in the same meeting, Chair. Thank you.
Right. Thank you very much. That's very clear and helpful. I want us to proceed, therefore, from that item, honorable members, and I want us to go to the next item, which again would also be influenced in a big way by the discussion we've just had. And that item is a preliminary work, skeleton kind of a program with lots of gaps and questions into it, because this team could not do things in your absence, because this committee drives the entire process. So I'm going to ask that we just get taken through as a way of creating this idea that this is the kind of program that we're going to have, because we do need to have a program so that we don't affect the work of other committees. And I'm going to invite the presenter to lead us in this. Would that be you, Thembi Kosingoma, or somebody else?
Thank you, Chairperson. Good morning once again, and good morning to honorable members. Yes, Chairperson, I will lead the presentation of this draft skeleton program before us. Honorable members, as you would notice on the screen, that the program talks to today's meeting, where you've just received the briefing by legal services and going through this program, and then which will be followed by the minutes. The Chairperson, based on today's discussions and what has been agreed on, we have a planned meeting for next week, because the outcome of this discussion will then afford the team the opportunity to go and draft the terms of reference, which we have then put for next week for adoption, as well as, Chairperson, that you mentioned earlier, that the discussion will also assist us to put more meat into the skeleton, Chairperson. So we would have also a finalized committee draft, because the intention for this one is just to get members to agree or sort of like discuss what we've presented before them. Following that meeting of next week, Chairperson, we have then reserved 2 weeks, actually 4 weeks, which is from the 5th of August until the 2nd of September. Those would allow for, as members have now agreed to proceeding with option 3, which does include a forensic expert. So that will afford such an expert together with the team, our legal services team, and also members to go through the document that has been made available to them, of which Chairperson at the end of this presentation, I'd also like members to probably give an indication on whether they would like to receive the 10,000 copies. I'm talking to those Chairperson in particular because they are the supporting documents of the independent panel report. So if members would want to receive hard copies of those documents, which would then be couriered to members, if so, if the committee so agrees. Chairperson, also the third yellow column row, you would see there that at least now we do have an idea of the forms the committee would proceed with its meeting, which is in this instance the hybrid model of meetings. And then, Chairperson, after the month of reading of documents, then we had scheduled a meeting for the 7th of September, where members will then receive a presentation from the CLSO, which is Mr. Ibrahim again, on the evidence before the committee. That is now after all the documents were read. And also in that meeting, Chairperson, it is then that would also decisions that will include the first audit being sent to the public protector will probably be agreed upon. And we've also then afforded another 30 days for that process to happen, which is the sending of the audit to the public protector and then the response of the public protector. I think, Chairperson, Ms. Fatima spoke strongly on issues of procedural fairness. Hence, you'll see the time allocated going to about 30 days. After the Chairperson will then receive, will then proceed, the committee will then proceed with its business, which is first with the briefing on the response of the public protector, because there would have been a response from that 30-day period that was afforded to the PP with the first audit. And after the Chairperson and honorable members, it will be followed by hearings. We have reserved 3 days of hearings from those witnesses that will be identified by the committee, with the last, my apologies, 4 days, but with the last 2 days of hearings being afforded to the public protector. After that, Chairperson, the committee will engage into deliberations up until the end of October. And then at the end of October, would request 2 weeks to draft a report. Of course, Chairperson, the report would be work in progress. It would not be that in that 2 weeks that we're requesting would be starting the report. The report would be work in progress. As the committee proceeds, the drafting of the report would also proceed. But just to look at just to make sure that we have a document that would agree upon as the support staff and management committee, then we requested that 2 weeks. And then after the Chairperson, the committee will have 2 days to consider the draft report, of which on the second day would request that would expect the committee to adopt such a draft. And it is that draft report, Chairperson, that will then be sent to the public protector as the second audit. And we have also once again reserved 30 days for that to happen, Chairperson. As you can see there in the yellow row, it will be from the 18th November to 18th December 2021. And at that time, Chairperson, Parliament will then be going also on a break and recess, and then we looking at then considering the responses of the public protector in the second week of January, and also adopt the the final report of the committee, which will be tabled to the National Assembly. Chairperson and honorable members, thank you very much. That is the draft program before you. It is a document, a working document, and members are welcome to make inputs because this is your document. Thank you very much.
Thank you, Mr. Ngoma. Honorable members, I see that you're already ready to engage with the report. That's an opportunity to do that. I now recognize Honorable Majosi, Honorable Jumat Peterson, Honorable Lotrit, followed by Honorable Dlakude, in that order. Honorable Majosi.
Thank you, Chair. Mine would be on the program itself. Firstly, maybe let's start there, where the support staff will be dealing with the reports. There's something on reports. Yes, it says from 1 to 12 November 2020, and I think we're on 2021. So I just wanted them to fix that before we even move forward in terms of adopting the program. Thanks.
Thanks, Honorable Majosi. Honorable Jumat Peterson.
Thank you, Honorable Chairperson. Greetings to you and greetings to the members of the committee. Honorable Chairperson, I'd like to thank you and the presenters for the presentations and for the draft program for the committee. The members have enriched the presentations, including the former one. Comrade Chairperson, Honorable Chairperson, I would like to propose that the draft program be considered in the light of the additions which were proposed earlier today and the recommendations which you have made in terms of finalizing the program. I propose that we adopt it as a draft program, and that once you have enriched the program, that it be presented to the committee for final approval. I so move, Chairperson.
Thank you, Honorable Tina Jumat Peterson. Honorable Lotrit.
Thank you very much, Chairperson. Yes, I think obviously, firstly, we have to be aware of the fact that, well, I see we have dates on what would have been the election dates, so it will also depend on the outcome of a competent court in terms of the election date. Secondly, Chairperson, if we look at page 2, the yellow blocks, and that is for 5 to 19 August, is reserved for the appointment of external specialists. That is what we have decided on as the hybrid now. Chairperson, will there be opportunity, because I know that these specialists, in my experience from powers and privileges where we had external evidence leaders, that there is a process where the committee actually is afforded the opportunity to look at possible or proposed names or companies, and that we can make a final decision, and that it is not purely an administrative matter. So would that be considered in this regard as well? Thank you very much.
Okay, thank you. Honorable Dlakude.
Thank you very much, Honorable Chairperson. Good morning to you and the colleagues. I want to support Honorable Chairperson. I will not go into making some comments. Honorable Peterson has already done that. I want to support the proposal that we adopt this program, and it's in order. It will allow us enough time to do our work as expected. Honorable Chair, thank you.
Thank you, Honorable Dlakude. The last hand, Honorable Siwela.
Thank you, Chairperson. I'm supporting the adoption of the program, but I want to indicate the issue of hard copies on the report, that it be couriered to us, because it's a big document. Thank you, Chair.
All right. Thank you very much for that. Tembinkosi and your team, just one or two queries. And my understanding is that, and one of the key queries raised by Honorable Lotrit on the issue that seems to me to be a procurement matter, but please speak to that.
Chairperson, I can speak to that issue.
Yes.
In terms of the FMPPLA, members of parliament are barred from serving on tender committees, but it also goes further to say that members may not participate in any other way in evaluating or approving tenders, quotations, contracts, or other bids for parliament. Of course, it is a procurement process. I will, however, raise the issue with our supply chain management. I don't see anything wrong with the committee engaging on issues such as the skill set that is going to be needed. What are we looking for in this particular person? So those sorts of issues can certainly be considered by the committee. I will look at the precedents that are being referred to, and then we can advise more fully next week, Chair. Thank you.
Thank you very much. I think that helps a lot. I hope Honorable Lotrit is connecting with that. Tembinkosi, on the other issues that you want to comment on?
Thank you, Chair. No, Chair, I'm covered by Ms. Ibrahim, Chairperson. I just wanted to also ask her to respond to that, since her office deals with the procurement of such legal minds. Thank you, Chair.
You also got the request about documents being couriered raised by Ms. Honorable Siwela. You are muted. You are muted. I can't hear you.
Thank you, Chair, and my apologies. Yes, Chair, I noted that, Chairperson, if the committee so agrees, or members, maybe, Chairperson, we should get members that would require the hard copies to contact the committee secretary. Chairperson, we're talking 10,000 pages. We're talking about 10 to 12 boxes of those paper rims that we often buy from stationery shops. So we're talking voluminous documents, Chairperson. Perhaps members that would need hard copies of the documents, which I've sent through a link last Friday, can then contact my office, Chairperson, and then we can then work from there. Thank you very much, Chairperson.
Okay, thank you, Mr. Ngoma. Honorable members, in terms of this item, I think the approach is that you'd engage with this draft, which is in itself informed by the earlier discussion, but the proposal is that we agree to it as a work in progress, a draft program, until finalized in our next meeting, taking into account all of the issues that members raised in this. And I guess, Mr. Ngoma, it would also be fair enough not to have this committee meeting Tuesday, Wednesday, Thursday, Friday, as if there are no other committees. We're going to have to agree even on particular days and particular times. That's work that would need to do. And then the issue of documentation, we have these options of a link, electronic as well as a hard copy, and I think the agreement is that those that would prefer hard copies would interact with yourself and raise that, so that we don't just produce documents en masse when people would not have preferred that kind of an option. And I think on the issue of the expertise that we're going to need, which involves procurement, that the committee will have a bite on the kind of skill set that we need, the kind of discussions, and more further work to verify that question will be done by Fatima Ibrahim. So probably all of those issues would come back and be finalized in our next meeting. With that, colleagues, I think that we can proceed from that item and get to our last item of the minutes. And on that item, the minutes have been sent to all of us. So I want to, perhaps you can start flighting them, Mr. Ngoma. So they are taken as read, simply because they were also sent to all of us. And I'm only going to ask if, having read these minutes, firstly, if there are corrections that you want to point out in the minutes. So there's an opportunity for corrections on the minutes, honorable members.
My name in there.
Ligai, Hari.
Oh,
no,
okay.
Chair, Honorable Mahlaule, the surname of my ancestors is Mahlaule, not Mhlaule.
Let's go there. Let's go there. What are you saying, Honorable Mahlaule?
No, it's corrected. It was written Mhlaule instead of Mahlaule, and it's not my surname. It belongs to the elders.
Thank you very much. Appreciate it. Any other corrections, colleagues? No other corrections on the minutes. I therefore take it that these minutes reflect the discussions and the proceedings of the meeting we had on the 20th of July. May I now ask if there's anybody moving for the adoption of these minutes?
I move, Chairperson. Comrade Violet, Honorable Sewell.
Yeah, there's a way to raise hand here, but I will take that. Honorable Suela is moving for the adoption of the minutes. And anybody supporting that? Honorable Hermans.
Thank you, Chair. I second the adoption of the minutes as tabled with the corrections, of course. Thank you.
Honorable Judy Hermans supports the adoption of the minutes as corrected. With that, honorable members, the minutes stand adopted. That brings us to the end of our items and our discussion for the Section 194 committee today. I want to thank all of you, honorable members, for being in the meeting and on time participating, directing how your own work must happen, raising your issues, clarities, and questions where you're not sure, so that things are clear as we proceed, as we start, because that is your space. It's important that we hear all of us out on those issues. With those words, colleagues, the meeting is adjourned until we meet next week. Thank you very much.
Thank you, Chairperson.
Thank you, Chair.
Thank you.
Thank you, Chairperson.
Thank you, Chair.
Thank you, Chair.
Thank you.
Thank you, Chair.
And that Matis. I can warn my Mr. Matis.
He's hiding.
Mr. Matis, what are you? Take off that mask. You're not supposed to cover your whole face.
He's hiding.